Review of record sealing reforms. Uh, Beginning in 2015, it's now possible to automatically have young people's records sealed. The thing to keep in mind, though, is that a lot of these reforms, including Section 786, beginning in 2015, as written, did not apply retroactively. So anyone who would be eligible for 786, who successfully completed probation prior to 2015, did not get their records sealed under Section 786 and would have to petition under 781. The other thing to keep in mind is that as originally written, Section 786 only applied to records maintained by the juvenile court. I think the legislature, when they created this, was thinking that it would apply to all juvenile records, but that's not the language they used. So they came back in and amended Section 786, beginning in 2016, to apply to all records upon the successful completion of either informal or formal probation beginning in 2016. But again, it wasn't retroactive, so anyone who would have been eligible in 2015 still had some of their records unsealed and would need a petition under 781. And then the next great reform took effect in 2018. And here you have Section 786.5, which now requires the automatic sealing upon successful completion of a program of diversion. This was that thing I referred to earlier, VORP in Contra Costa County, where petition is not filed and young person has no court involvement. Then you also have the automatic sealing of all records upon the dismissal of a delinquency petition without it being sustained. And so the idea here is that not only are we going to allow young people to seal their records after they successfully complete probation, but even for those young people who have a petition filed against them and the court decides these allegations aren't true, they should also benefit from juvenile record sealing. And it should be automatic so that if they are innocent and they have been wrongfully accused, they shouldn't have to go through the same burdensome process as someone who was on probation, had been found to have committed those offenses, and doesn't qualify under Section 786. And then the other really significant reform starting in 2018 is that it's now possible to seal the majority of 707B offenses under Section 781, as long as the petitioner is able to show that they've been rehabilitated and they're otherwise eligible. That is a significant reform, and I am now reaching out to clients who were previously ineligible but now can apply under Section 781. So what makes a young person eligible under Section 781? Here I have 5 criteria. So number 1, they must not currently be a ward of the court and must be off juvenile probation. Number 2, it must be true that they are now 18 years old or that 5 years have passed since they were arrested or terminated from probation. In most cases, this will mean that the person have been 18 years old because the vast majority of young people who are arrested after they're 13 or older. And so in most cases, you're going to want to look to see, are they 18 years old, or are they in that small number of people who were arrested, really early on, and maybe were never on probation and don't have to wait until they're 18. But then you're also going to want to ask or make sure that they have not been convicted of any felony or a misdemeanor involving moral turpitude since their arrest or termination from probation. And so again, there's a difference between a juvenile adjudication and a conviction as an adult. So this is after they turned 18, or if they were tried as an adult younger than 18, make sure that they have not been convicted of a felony or certain misdemeanors, and I'll talk about which ones are disqualifying. Then the big thing that you're going to want to focus on is that the young person be able to show the juvenile court that they have been rehabilitated. And lastly, it must also be true that they were not forced to register as a sex offender pursuant to Penal Code Section 290.008. So there are certain offenses where young people will have to register, but the thing to note is that if a young person was never committed to DJJ, what used to be known as the California Youth Authority, then the youth will not have to be required to register. So that's why it's really important when you're doing the screening to ask young people if they were sent to DJJ, because that will give you an idea potentially about whether they had to register or not. So what exactly is a misdemeanor that involves moral turpitude? The answer is no one really knows. So the phrase as used in the statute is not defined, and there aren't any published appellate decisions that really deal with this process or with this phrase for juvenile record sealing purposes. Now there is case law about felony convictions that involve moral turpitude for purposes of impeaching witnesses at trial, but it's not clear whether that's the same and what it would mean in a misdemeanor conviction. I would say that if it's a misdemeanor that involves dishonesty, maybe that involves moral turpitude. Perhaps if it's an offense of a sexual nature, that might be moral turpitude, but we really don't know. So I would say that young people, even if they have a misdemeanor conviction, should try to get their record sealed. And if they're denied, they could always try to get that misdemeanor conviction expunged and try again in the future. So when in doubt, try to get your record. So going back to eligibility under Section 781, what does it mean for the court to find that you've been rehabilitated? So I have a slide here. What does it mean to be rehabilitated? This comes from an appellate decision in Re JW. I have a good quote here. The term rehabilitation is by its nature predictive. So the term is by its nature predictive. An applicant seeking to seal his or her juvenile records must make a showing sufficient to convince the court that criminal behavior is in the past and will not be repeated. This is a determination based on the totality of the circumstances, and individual factors will inevitably vary. It is the life that the juvenile has lived that will direct the trial court's ruling. So the things to focus on is that juvenile courts have a broad amount of discretion that they can use to consider whether a person has been rehabilitated, and it's a test based on the totality of the circumstances. And it's about the individual nature of the young person and their rehabilitative needs when they were on probation. So you're going to look at what their needs were, whether they had some struggles on probation, what those were, and how you can convince the court that even if they were unsuccessfully terminated from probation, they are unlikely to engage in similar criminal activity in the future because they have engaged in services and have turned their life around, and that those youthful indiscretions were really just young mistakes that the person has now grown out of. So factors that the court consider include the seriousness of the offense. This comes from the JW ruling. One thing to keep in mind, it's now possible to seal certain 707B offenses, but because courts can consider the seriousness of the offense, it's sort of an open question as to what courts will consider when a 707B offense is presented in front of them. Maybe they will require a greater showing of rehabilitation. They can also consider the length of time since wardship was terminated and whether the person was successfully terminated from probation. So the way to think about this is a young person who today is unsuccessfully terminated from probation, they can immediately apply if they're 18 years old and don't have some disqualifying conviction. But will the court really consider that they've been rehabilitated if they were just unsuccessfully terminated? So the court is going to look at this and say, you struggled when you were on probation, you had a lot of probation violations, maybe you had a substance abuse issue and you tested positive for illicit substances frequently, what is really going to convince us that those, issues are behind you and that, these issues aren't going to present themselves going forward? Other things that the court consider are the young person's educational attainment, their employment history, and I've also included participation in therapy or completion of substance abuse treatment. This isn't something that's stated in the statute necessarily, but when I'm looking at individual factors, I'm thinking, what were the issues that the young person had on probation? And, are they things that you can say have been addressed because of participation in therapy, because of substance abuse treatment, or other services or programs? Things to keep in mind, though, the court cannot consider unpaid victim restitution or outstanding restitution fines and court-ordered fees. So that comes actually out of the statute itself. If you look at the packet passed around, that the probation department's record sealing packet in Contra Costa County, they have some language in there that the young person not have any unpaid tickets or restitution. So that is incorrect legally. Clearly, they don't understand the law, but the juvenile court should not be considering these factors. So, young people should know that even if they have unpaid restitution or unpaid fines or fees, that they should have the confidence of going forward and trying to get their record sealed, because the court cannot consider those factors. So who actually would benefit from sealing? The short answer is that anyone who is eligible for sealing under Section 781 and who has unsealed records would benefit from sealing. So these questions I've included on this slide are designed to help you try to figure out whether the young person is eligible and whether they have records that have yet to be sealed. So if they were arrested at any point before they turned 18, and even if they were never charged with an offense, those records will still be out there and could come to haunt them in the future, particularly if they want to enlist in the military. And so they might want to consider getting their records sealed. Also, anyone who completed probation unsuccessfully at any time will have their records unsealed, because there's no automatic process for people who unsuccessfully completed probation. And then you're going to want to look at the Section 786 and 786.5 situations, and then focus on when those things happened. So if a young person completed probation, either formal or informal, successfully, but it happened prior to 2016, then they'll want to try to get their records sealed under 781. If they completed a program of diversion before 2018, again, they're going to want to try to go in under 781 and get those records sealed. And then similarly, if their petition was dismissed without it being sustained, but this happened before 2018, then they're going to want to go in and get their records sealed under 781. And then finally, also, if they completed probation, but they were found to have committed a 707B offense that occurred on or after their 14th birthday, then they may now be eligible for sealing under 781, and they're going to want to try to get those records sealed. The one disqualifier, though, is if they were forced to register as a sex offender under Penal Code Section 290.008. Okay, so again, what does it mean to have completed a diversion program? Going back to that slide, that's a program in lieu of a delinquency petition that happens without court involvement. What does it mean to have a petition dismissed without it being sustained? So going back to that tree again, that is when the petition actually is filed and the juvenile court dismisses it, either because the DA asked the court to dismiss it, or the court finds that there isn't evidence sufficient to convince the court beyond a reasonable doubt. And so you might have asked yourself, earlier when I was talking about the difference between 781 and 786, I noted that there is a difference in terms of the remedy under 781 and what gets sealed versus 786. And so that's also true under 781. when a young person has a 707B offense that happened on or after their 14th birthday. So if they do have a 707B offense that happened on or after their 18th birthday, and even if they get their record sealed under 781, the district attorney, probation department, and courts will actually be able to use these records against them in certain future criminal prosecutions. So the thing to keep in mind is that under 781, 707B offenses are treated differently, and so that will result in not the full scope sealing remedy, but what I call sealing light. Now, there is an exception here. So even if you have that 707B offense that happened on or after their 14th birthday, if it was a felony that was reduced to a misdemeanor, so that would be an offense like Penal Code Section 245A1. If it was charged as a felony reduced to a misdemeanor, then they get the full benefit of record sealing. If you have a felony only 707B offense, like 211 robbery, then you will have to actually get that dismissed under Section 782 in order to benefit from that full scope sealing. So moving on, you might have asked yourself, what is the 707B offense? I'm sorry if this was in the back of your mind, but here I have two slides that list in great detail all of the different categories of 707B offenses. There are 30 categories, so you don't have to memorize them because it gets pretty complicated. The thing to take away from this is that these offenses are generally serious crimes. Most are felonies, but some are, can be reduced to misdemeanors. And you're going to want to consult this list to find out whether a person has a 707B offense. The other thing to keep in mind is that young people are sometimes confused about what the offense was when they were arrested, what the police report said, what the charge was as it was, alleged in the delinquency petition, and then what they either pled to or what the court sustained after trial. And so you don't want to rely just on what the young person remembers because it's possible that they misremembered it. You're going to want to actually take a look at those records in order to find out, was it a 707B offense or did it even happen before they were 14 and it doesn't matter. So when you're actually speaking to young people, here's some questions I've included to help you determine whether they would be eligible under 781. You're going to want to ask at what age were they arrested. So if it happened after they turned 18, then they're not going to benefit from juvenile record sealing. You'll also want to ask which law enforcement agencies have records. So which police department were they arrested by? There was a question, will we be able to help people who were arrested or on probation in another county? Well, that will depend on where their case was and which agencies have records. So I'll address that in a minute. You'll also want to ask, were they ever placed on juvenile probation? If they were and they were successfully terminated from probation, they might have their record sealed depending on when that happened. Were they ever tried as an adult? So that will help you figure out whether they have a felony conviction that would disqualify them for record sealing. Then you'll also want to find out whether they have any recent arrests or any open or pending cases, because a juvenile court might say, you have this recent arrest, you have this open case. We want to wait until that plays out to figure out whether you're going to be convicted to help us decide whether you actually have been rehabilitated. They are entitled to a presumption of innocence, but the court is going to want to say, we want to see how this plays out before we make this decision on whether to seal your offense. Then you'll also want to ask them how old they are now. So if they're under 18, they are most likely not going to be eligible unless 5 years have elapsed since they were arrested or terminated from probation in those rare number of instances. And then you'll also want to again ask if they were ever sent to CYA or DJJ, the Division of Juvenile Justice. In my experience, most young people will know whether that happened. So they actually will have a good idea and will be able to tell you pretty accurately whether that happened. And this will affect whether they are eligible for sealing and also what the effect of sealing will be. Then I also included a couple questions to determine whether they have been rehabilitated. So you'll want to ask you'll want to find out whether they were ever adjudicated delinquent and made a ward. These are not typically words that young people will use when describing themselves. So you might want to ask them, were you ever on juvenile probation? That tends to be how they think about it. You'll also want to ask them how much time has passed since they were terminated from probation, because again, that will impact whether the court will find that they've been rehabilitated. If they were just terminated unsuccessfully, maybe the court will say no. If they are now 40 years old and a lot of time has passed, that is really good evidence that they've been rehabilitated if they have no convictions recently or at all. And then you'll also want to ask about their education. Did they graduate from high school? Do they have a GED? Have they attended even some college? Do they even have an associate's degree, a bachelor's, or a graduate degree? All of these things will weigh heavily in favor of rehabilitation. And you'll also want to ask about whether they're working or have work experience, especially if they have recent verifiable work experience, because the juvenile court isn't just going to take young people at their word. They're going to want to actually have documents to verify that they're working. And then finally, you'll also want to ask them if they have anyone who can write a strong letter of recommendation. So typically this will be a recent or current employer, a teacher, a pastor, a mentor, or a service provider, including a therapist. These are all things that will help them show that they've been rehabilitated. And so, part of the goal for today is to understand what the record sealing process is, so that you can give young people a clear idea of what that process is going to be from start to finish. So the first step in the process is to actually complete a record sealing petition and submit it to the appropriate probation department. So there is a standard judicial council form that they can use. But what we find is that generally every county has its own proprietary form. So it might be a good idea to use that county's form. In your materials, we've included one from the Contra Costa County Probation Department and also one from the Alameda County Probation Department. And so, which probation department will they have to turn their form into? It depends on where they were arrested and whether they were ever made a ward of the court and placed on probation, and in what county did that happen. So take, for example, a young person who is arrested in Berkeley. If they were never placed on probation, then they're going to have to submit that form to the Alameda County Probation Department and try to get that Berkeley Police Department record, sealed under 781. But if they were arrested in Berkeley, found to have committed that offense, and then the case was transferred to Contra Costa County for disposition because they were a resident of Contra Costa County, then their case was in Contra Costa County. And if the case was terminated in Contra Costa, even though all of the arrest and the incident happened in Berkeley, and even though Alameda County has certain records, they are going to be required under the California Rules of Court, Rule 5.830, to actually petition in Contra Costa County and try to get those records sealed. Because if they were placed on probation, it matters where the wardship was terminated. And in this case, if it was terminated in Contra Costa County, that's the appropriate county to petition to. And so in the intervening time after they have submitted this petition to the probation department, hopefully the right department, they'll want to gather documents to prove that they've been rehabilitated. So these would be letters of support, transcripts to prove that they've graduated from high school, have attended college, maybe pay stubs, an employer ID to show that they're working, things like that. The whole process will, under the rules of court, it's supposed to take 90 days if all the action happened in one county, and up to 180 days if there are multiple counties involved. So that's what the rules of court say, although in practice, I've seen this take far, far longer. So unfortunately, a lot of uncertainty has happened because of the recent changes in the laws. A lot of agencies are changing their policies and practices, and so that has created some delay in the system. And you'll want to let young people know off the bat that even though it's supposed to happen within 90 days in most cases, it might actually take longer, and they should be prepared to wait maybe a little bit longer than that. But eventually, the case will be assigned to a probation officer who is supposed to be investigating their petition. So they will actually interview the young person, try to get records that show that they've been rehabilitated, and they'll write up a report. And so, these conversations that we're going to having with the young people at the clinic will be very important because we'll be asking them questions to determine whether they've been rehabilitated, and that will actually help them frame, the entire case for the purposes of this interview. And so they'll want to focus on, the things that we're asking them, whether they have, graduated from high school, gone off to college, if they're currently working. They're going to want to focus on all these things when they're talking to the probation officer so that the report is as strong as it is and we get the best recommendation possible. And then, under the rules of court, the sealing hearing is supposed to happen within 90 days if there, is, in some cases, it's possible that if all the parties agree that they should get their record sealed, maybe the judge will sign the record sealing order without a hearing. That's the way it seems like it's going to be shaking out in Contra Costa County. But it's possible that there will be a hearing and they may have to attend, depending on what the judge says and whether they still live in the county. We'll let them know that they may need to actually physically attend a hearing, but they will get notice of the hearing. And that's why it's important for them to put an address on the petition where they receive mail so that they get that notice of a hearing and know when to attend. And in the best scenario possible, the petition is granted. The juvenile court orders their record sealed. The clerk sends out the record sealing order to all listed agencies, and the agencies are supposed to seal the records within a certain period of time. And then once they have sealed the records, they're supposed to send a notice to the clerk so that the court knows that all of the records have been sealed, that all of the agencies have complied with the court order. And once that occurs, the court is supposed to send a notice to the young person to let them know all the agencies have complied, all the records have been sealed. However, if the petition is denied, perhaps because the court finds the young person has not been rehabilitated, the petition will be, dismissed, but will be done so without prejudice, which means that the young person can apply in the future because it's all about have they been rehabilitated. If that hasn't happened yet, that doesn't mean it'll never happen, and they have a chance in the future to show the court that they have been rehabilitated. So they'll want to, focus on those rehabilitation factors. The court might decide to set a hearing 6 months down the line, 1 year down the line, or maybe they'll just dismiss it and say reapply again, from the beginning. So it'll depend on what happens in court. So that is, the training for right now. Does anyone have any questions? Sorry. Go ahead. Moral turpitude. Yeah. So the comment or question was that this is all very discretionary and it's not clearly defined what a misdemeanor involving moral turpitude is. And yes, that's definitely a big flaw in the way that the statute was written because it doesn't provide enough clarity for the courts. And so, that also highlights the importance of having an attorney there at that record sealing hearing, able to make that legal argument that, the person has been rehabilitated, that this misdemeanor conviction is not one that involves moral turpitude. Any other questions? Oh. Oh. Okay, good. So the question was the recent amendments to, I think, Section 786 that it was created in 2015, then amended. Amendments took effect in 2016, which now applies to not just juvenile court records, but also records by all law enforcement agencies. So the way that works out is if a young person was successfully terminated in 2015 and had their juvenile court records sealed, then all the police departments, all law enforcement agencies would not be required to seal their records. So they'll want to petition under 781 to make sure that they have all their records sealed. And then the other thing to keep in mind too is that even if you do have your records sealed under Section 786, the remedy under 781 is far greater because it prevents those records from being used in future prosecutions unless you have a 707B offense that happened on or after the 14th birthday. So under 786, young people might actually decide, I want to get my record sealed again under 781 to protect me in the future. That's a good question. Did you have another?
I did. I know that you mentioned records, and I was wondering how allowed to see what's in
So if their records have not been sealed, they will be able to go to the clerk's office, bring an ID, and get a record of get their juvenile records. If their records have been sealed, then they may be unable to get a copy of their records without a court order. And there are certain reasons where a person will be able to get a copy of their records. Say, for instance, there's a defamation lawsuit, and they want to get a copy of the records to show that they what they said was true. That might be a situation where they'll be able to get a copy of their records. And there are other things listed out in the statute itself.
So I have three.
Sure.
The first, you were just talking about the different. Is best practice also?
So the question was, is it a matter of best practice that once a young person has their record sealed under Section 786 to try to get it sealed under 781? And yes, that would be ideal. Unfortunately, 781 is a cumbersome, time-intensive process. But luckily, in Contra Costa County, even when a person gets their record sealed under 786, my impression is that they actually get the Section 781 sealing packet and are instructed that if they want to, they can petition to get the record sealed under 781. Now, I don't know how often that happens because I think for most people, they say my records have been sealed under 786. That's enough peace of mind for me. And for most people, that will be enough. The great thing about 786 is that even though those records can be used against them in future prosecutions, they're still entitled to that legal benefit that the events were deemed to have never occurred, and they can apply for jobs in colleges, generally as though it didn't happen. So that's a good question.
The second question you touched on already. Also, you were talking about Rule 5. In terms of where to file. But again, best practice to file in the but also to file other counties, contact law enforcement. Even though if you get it granted, the court is supposed to contact other law enforcement. Again, as a matter of just making sure, is it advisable to also?
So the question was, under Rule 5.830, you're supposed to, submit the petition in the appropriate county. What happens if there are multiple counties involved? Should you submit that petition to all the different counties in order to make sure that all the records are sealed? And what I would recommend is to, submit it to the appropriate county. But you'll also want to look at each individual case. So going back to that example, a young person arrested in Berkeley lives in, say, Richmond. Maybe there are two arrests. Maybe there was one arrest in Berkeley, no charges were ever filed, then later was arrested in Oakland. The case was transferred to Contra Costa County, and they got off probation unsuccessfully. Later are trying to get it sealed under 781. That is actually going to be two petitions submitted to two different counties. So the Berkeley, arrest, you're going to have to petition in Alameda County. The Oakland arrest that was transferred to Contra Costa County will have to go to Contra Costa County. And the reason that's important is that even if someone has their record sealed under Section 786, so say in this case, arrested in Oakland on probation in Contra Costa County, successfully completed, say today, gets their record sealed under 786, that will not actually impact the Berkeley arrest for which no petition was ever filed, and they'll have to try to get that arrest sealed under 781 in Alameda County.
And the last question is, California DOJ, is it possible to from a person or record of arrest of a person?
So the question is, even though sealing applies to the California Department of Justice, is it possible to get that entry deleted in the CINI? That is a really good question. I am less familiar with the California Department of Justice's practices. I know that it's pretty standard that if the California Department of Justice has, records that are incorrect, you can, send a letter to them to try to get those records corrected. So I imagine it would be possible to try to get those entries deleted if they've been sealed under 781, but I'm not entirely sure. Any last questions? So the question is, someone who should have had their record sealed under Section 786, but for the fact that it happened, prior to 2015, 2016, 2018, would they still be subject to, proving that they've been rehabilitated? So my position, and this is generally sort of played out in court, is that if you were successfully terminated from probation and it's not a 707B offense that happened on or after the 14th birthday, then in my mind, that is per se evidence of rehabilitation, assuming that there isn't an intervening adult conviction. And so, in order to actually be successfully terminated from probation, you have to show that you've substantially complied with the terms of probation, that you've been generally successful, no new findings of wardship or convictions, generally very few, if any, probation violations or, no recent ones. And so that would be really good evidence of rehabilitation. And it's also, I think, powerful to say, look, Judge, if, my client had been successfully terminated from probation, this year, they would have been eligible for automatic record sealing. So therefore, I'm asking you to find that they've been rehabilitated. And generally that has played out. Now with the recent amendments allowing people to get their record sealed for 707B offenses after they turn 14, that's sort of an open question. Maybe judges will want to find or will ask for more evidence of rehabilitation, and will maybe ask for a greater amount of time in order to grant those petitions. So I'm not entirely certain, but I do have one case where someone was successfully terminated from probation. At that hearing, the judge said, "I really wish I could, seal your records. Unfortunately, the law does not allow me to do that." And now I'm able to ask the judge to seal her records. And in this case, even the district attorney is saying, yes, she definitely should get her records sealed. So hopefully that is what's going to start happening going forward. All right, so I think we're out of time. Now I will turn it over to Meredith to talk about vacature and sealing.